Well, glad to have you join us back on our TVC broadcast. Just while we were away, we had a lawyer join us, Tony Odiadi. Glad to have you join us here on the program this morning. We still have Gbola Oba here. Both of them will do justice to the question of asset declaration. That's what we're talking about earlier on. We're looking at the fact that Gbola was trying to paint a picture that the job that is cut out for the CCB is quite cumbersome.
But of course it is. Of course the CCB has enormous responsibility. If we say, for example, that public officers and certain categories of officers must have certain codes of conduct, the CCB is to superintend that, is to find out if there is adequate compliance, and it sets certain kinds of modalities such as asset declaration. If you have an asset declaration form, it means you'll be indicating in that form the assets that you have as at the time that you're stepping into that office. Now, you're obliged to be truthful to it. You're obliged to do what it is that you have as your assets, so that it will be a benchmark for assessing you in subsequent years, so that anybody who wants to assess whether there were some kinds of corrupt enrichment or enrichments which are not easily explainable, that form which you have filled will be a proper, objective platform for assessment. So it's such an enormous task now for the CCB, because we have a lot of things to do, a lot of verifications, a lot of tracing, a lot of assessing, a lot of finding whether it is true or it is not true, where people put down their assets. So to that extent, you'll see that the job is enormous, but nonetheless, it is doable. So long as individuals step forward and are ready to comply, it's such an easy thing to do. But the human nature is such that people may want to be elusive, or people may not want to be wholly compliant, So that's where you begin to have these kinds of challenges, which we're already having. The public officers in declaring assets, times dodgy, times, not too sure what they need to put before the public domain. And all of these things are the complications that we have. But that's why you have the Bureau.
All right. We've always talked about asset. While I was doing my research before coming out, I threw some questions out there in the public domain. And one of the respondents said to me, all right, we declare assets, fine and good, but then we never really seem to talk about liabilities. And then he said that somebody might declare his assets and then eventually have liabilities that he could cover up with the acquired wealth up to 1,000%. I want you to look at that. Have we ever really talked about, or is it not included?
It's included. You find it there. As a matter of fact, if you're declaring your assets, you ought to properly declare your liabilities as well. If I say I own a property on Allen Avenue, and the property is under some kind of mortgage, or some kind of charge, some kind of pledge upon it, I should indicate it. Because except I vacate that mortgage obligation, it's not exactly an asset. Yes. You get the point? So it is inherent in the process that if I'm saying I have a property here, but I'm indebted to Union Bank for to the tune of 5 million, I should be able to put all of this together, because the purpose is to know my exposure, what I have and what I don't have. So that's the way it is. What really is the issue is whether in subsequent years it turns out that there has been some falsehood in the declaration. When there's falsehood, that is where the act begins to
work.
Begin to work.
All right. Bola.
Of course, you can declare anything. You can say, so long as it is true, I own this property, I own these cars, I own this, other things. I own these shares. Nobody quarrels with you. You're only it's up to the public to say, oh, we thought this man was a simpler man, or we thought he wasn't this. So it turns out that he's the owner of the social property. Nobody bothers you about that, except somebody triggers the process to say, no, that property is not yours, or whatever. But people are shy. If it is true that you are the owner of number 10, Queen's Drive, so be it. except there is an inquiry as to whether you are indeed the owner. That's when it becomes an issue. For the purpose of CCB, it's just for you to put it there, and it begins to go. Anyway, because it's a public document, if I want to make inquiries, I can go in and look. But people, see the confidentiality of it, and that is actually part of the things that go.
Now, he's brought in something, Gbola Oba, the responsibility of determining how and on what terms asset declarations will be made accessible to the public was left to the National Assembly.
You must be very careful the way you're presenting that. There is an instant law in Nigeria that is called the Freedom of Information Act.
I'm coming to that, yes.
And, under the context of the Freedom of Information Act, if you present a genuine reason to the Bureau why you should see Mr. Gbola Oba's asset declaration form, if that request complies with the provisions of the Freedom of Information Act, you'll be obliged. So it is a public document. Am I right? Because I don't want to pretend to be a lawyer.
Because from what I have gathered, there is a lacuna there in the FOIA Act. That even though, yes, you can go to them to ask the CCB to, show you the assets declared by...
Not only the CCB, any public...
Good.
But there are rules to avoid abuses.
There must be certain prescribed requirements. I mean, you must demonstrate, just like going to court, there must be some locus. You don't just step in and say, I want to sue such a person. You must demonstrate that you have a stand upon which you want to move the legal process.
No, not even the legal process.
Just using that as an example.
I'm telling you
that. As a parallel line.
Yes, for you to say you want to examine, the asset declaration of some public official under the Freedom of Information Act, you are expected to demonstrate why you have a particular interest, and that interest must be reasonable.
Oh, yes, must be reasonable.
Yes. Then that will really make it difficult. When we say reasonable, what are we looking at here?
Of course, because there cannot be frivolity. You cannot just, for the purposes of whatever you might think, some kind of fancy, You need to demonstrate that there is a reason why you need to get this information. And
that is why people like us, that is why somebody like myself is celebrating the voluntary nature, the voluntary public declaration of people like the president and the vice president. Because under the law, ordinarily,
you're not supposed to do it.
To be honest with you, in so much as I even celebrate the voluntary public declaration of the president's and the vice president's quote-unquote asset declaration, after reading the Code of Conduct Bureau and Tribunal Act, I want to believe that what has been made public, it must be inconsistent with what they have submitted to the Bureau. You know why? Because in the Act, under asset...
Must be inconsistent.
Must be inconsistent.
How do you mean?
That's what I want to explain now.
Okay.
In the Act, you are supposed not only to declare your personal asset, your spouse's asset, your children under the age of 21 who are not married. If you look at the public material now that we have from the president and the vice president, it only enumerates their own individual. In each case, we have each public officer's assets enumerated. And you must remember that under the Code of Conduct Bureau and Tribunal Act, although the title of that segment, Section 15, is actually asset declaration, but like my brother rightly said earlier on, it includes
liabilities.
Declaration of liabilities. Now, in the case of the president, let me give you a typical example. We have to celebrate what is a move, what is a progressive move.
All right, he said this. This is quite interesting. When I read it, I had to bring it out. He also said the allegations were a reflection of saying that each time you fight corruption, the system will fight you. And I'm wondering, who is fighting corruption here? Is it the CCB or CCT that he's been dragged to, or the Senate President? I want you to evaluate that statement.
That statement must be taken in the context of the fact that he believes, the stretch of it is that he believes that he's being witch-hunted, and he wants to tie it to the ongoing investigation in the chamber of the Senate on the energy,
the power project,
the power investigation, and the fact that he called on Lamode, which we know was a political move. Which I think is a political move, because some people will disagree with me. So he's trying now, within the context of his circumstance, to find a toga of heroism to wear and say, you know what, I'm being this vilified, or I'm being persecuted because I'm the leader of a chamber that is taking this legendary heroic step.
But that's not particularly the point. The point is, did you declare your assets when you were supposed to do them?
Simple.
Did you anticipatorily declare assets? And that should be the fulcrum of this argument.
You must understand, just like you rightly said, you find a situation in which everybody says he's fighting corruption. There's an investigation in the chamber going on for the energy sector and all that. There's even an investigation of the Lamode
allegation against Lamode.
Yes, all of those things are going on. And let me tell you, our political systems are interconnected. I know you know me, he knows him, we all know each other. And anybody
can move from one party to the other party.
So we all are going around with our skeletons, as it were. So anybody can turn around and say, listen, I'm fighting corruption by investigating your activities. And then it turns out that you also can fight me in a response to the fight for corruption. Do you understand what I'm saying? So you've seen that kind of a situation. So anybody takes the heroism of fighting corruption. The truth of it is that you make it simpler. The question before you is, was there an asset declaration? And
was it properly done?
Was it properly done? Did it
was
comply?
It done in compliance with the extant law?
There is another issue which has come up. And let me tell you, there's no tribunal that is beyond censure or beyond investigation. If a tribunal like the CCT is being queried in the Federal High Court, it does not behove on the tribunal to say, I do not recognize the Federal High Court. It must wait and see what the Federal High Court will say, because this matter has been dragged to the Federal High Court.
But does the Federal High Court have... now, maybe you should trash that.
That is the issue. The issue is whether the CCTV is a full court of record whose activities will be beyond censure of a court of the ample jurisdiction like the Federal High Court. The man says, my rights have been threatened. The CCT has its own jurisdiction. Final decisions from the CCT goes to the Court of Appeal, no doubt. But certain procedures of the CCT, if you think that it has become abusive and all that, we are dealing with something which has not been done before. We call it res integra in law, something which has not been done before. It has gone to the Federal High Court. The judge in the Federal High Court says, yes, I need to find out whether some rights have been impinged. It is part of legal development to wait and see how it goes. It will be a kind of a call to anarchy if one place says, no, we're not interested. You have no rights to.
Without being a lawyer, I have a little disagreement with my
because I was going to also raise the fact that, before you come in, raise the fact that
without being a lawyer,
banded. Okay, go on.
Without being a lawyer, I have a little disagreement. And my disagreements are predicated on these grounds. One, he went to the Federal High Court to get an ex parte decision, and the court had never granted him what he sought. They said, get the other party to come and tell me why I should not grant you.
Good.
No, that's number one. No, that's number one. That go get, I'm having an issue with him.
Yes.
I quickly came to you to report him, and you said, Gbola, before I can take a decision on this, just for the purpose of fairness, get him to come and tell me, to tell you why
Put them on
you
notice.
should not
Yeah.
grant
Yes,
me.
put them on notice.
That's number one. So, a substantive injunction had not been given.
not been
Number one.
given,
Number
yes.
one. Number two is this. President Goodluck Jonathan did Nigeria a favor. Indeed, it's one of the reasons why I have a little bit of reservation with the initial dilly-dally of the Buhari administration. President Goodluck Jonathan, at the very wee hours of his administration, did Nigeria a favor. He signed into law a bill which now is called the Administration of Criminal Justice Act. In the Administration of Criminal Justice Act, one major Malay that has traduced and indeed abused our criminal justice system has been addressed in that act. And that is, if you take anybody who is rich to court in Nigeria on a criminal matter, say fraud, or anybody who is rich, in so much as that person has about 50 million to 100 million naira ring-fenced to play lawyers, you know what they do? They will first start on the issue of jurisdiction, go to the Supreme Court, come back. When they get back from on the issue of jurisdiction, they will start on the law of evidence and go to Supreme Court. 14 years has gone.
That is good. That is good.
You know what
That is good.
You know what the SCJ has done.
That is good.
You know what the SCJ has done. The substantive issue, which is now timed, must now be heard concurrently with all legal issues. I want to believe that in the face, I am not a judge, but I want to believe that in the face of the extant rules of the Administration of Criminal Justice Act,
Justice Umar made his judgment.
no, it's not a justice.
Sorry.
You must call him Mr. Muhammad. That is
Because
another.
the CCT.
Although he's of a status of a High Court judge, anybody appointed into, but I would rather call him Chairman Danladi Umar. He's right in the face of this thing.
This now you now come to the point.
All right.
Because
just hold your thoughts. You will continue from there. Ogaba from Benue State, let's have you. Thanks for calling in.
Yes, in the morning, and regards to the guest in the studio.
Morning to you.
I want to say that this idea of a court that has this idea of challenging jurisdictions is like contradictory, because if you're asking a court not to do, I think what is obtained in the court, or anybody approaching the court is looking or seeking for justice. And if you're challenging the jurisdiction now, it's like you're asking the person who is approaching the court for justice not to do so. I think these things need to be clearly set out in our law statutes. And the way the prosecution went about, I was impressed the way the prosecution went about their case. That even they brought out an issue, a Supreme Court ruling that said, even when an order is given by a federal high court, which is at the same level with the tribunal, it doesn't stop the case from going ahead. So what is all the contentions? These things are already clear. The defense, the prosecution has made this case, presented this case very clearly. So by that Supreme Court ruling, I think there should be no contentions. This case is a very clear case, and it should move ahead very smoothly. God bless Nigeria. Thank you.
Thank you very much. Yes, your thoughts. Thank you very much, Ogaba.
Let me make the point. Fundamentally, every citizen has a right to seek legal redress.
Yes.
If you feel that your right has been impinged upon, you can seek avenues for some redress, some review, some, certain kinds of defenses. Now, the simple thing is for you to appear before a tribunal. If you, under some legal counsel, some legal advice, feel that, no, this tribunal is not approaching its case in the proper way, or you suspect that the tribunal does not have the right jurisdiction, you can seek some redress elsewhere. The idea is this: is not to foreclose or presume that somebody is already guilty until proven innocent. That is the danger. if this process, which is ongoing, turns out that the Senate President ought not to get to the Federal High Court, of course, he returns to the CCT, and then the procedure will go. For us to say, no, do not go there, do not go there,
sir.
or you're going there
sir.
is wrong.
All right,
It
all right,
is
all
wrong.
right. Hold
No,
on,
sir.
hold on,
Let's-
Bola. Hold on. Let's not take.
I would love to
the
respond
law.
to my
Let's
to
not,
my brothers.
So-
No, it's not the issue of the law. It's the issue of enlightening our viewership.
No, listen, this is not a question of, listen, the point is this. There is a forum which,
I agree that
at times in law,
fundamentally-
it will look as if it's an experiment. Why have you gone to test whether the Court of Appeal should do this? The Court of Appeal says no, you return. Why have you gone to the Supreme Court to see whether there has been some abuse in the Court of, in the Court of Appeal? The Supreme Court says no, you return to the Court of Appeal to go and